Pardoning power and executive clemency. Section 19, Article 7. Except in cases of impeachment, or as otherwise provided in this Constitution, the President may grant reprieves, commutations and pardons, and remit fines and forfeitures after conviction by final judgment. Forms of executive clemency. Reprieves. A temporary relief from or postponement of execution of criminal penalty or sentence or a stay of executio. It is the withholding of a sentence for an interval of time, a postponement of execution, a temporary suspension of execution. Commutations. Reduction of sentence. It is a remission of a part of the punishment, a substitution of a lesser penalty for the one originally imposed. Amnesty. A sovereign act of oblivion for past acts, granted by government generally to a class of persons who have been guilty usually of political offenses and who are subject to trial but have not yet been convicted, and often conditioned upon their return to obedience and duty within a prescribed time. Amnesty requires concurrence of majority of all members of Congress. Pardons. Permanent cancellation of sentence. It is an act of grace proceeding from the power entrusted with the execution of the laws, which exempts the individual on whom it is bestowed from the punishment the law inflicts for the crime he has committed. It is a remission of guilt, a forgiveness of the offense. Parole. The suspension of the sentence of a convict granted by a parole board after serving the minimum term of the indeterminate sentence penalty, without granting a pardon, prescribing the terms upon which the sentence shall be suspended. Pardon. Plenary or partial. Plenary. Extinguishes all the penalties imposed upon the offender, including accessory disabilities. Partial. Does not extinguish all penalties imposed. Conditional or absolute. Conditional. Partial extinction of criminal liability. It does not restore political and civil rights, unless expressly so provided. Has no effect if not accepted by the condemned. The offender has the right to reject the same since he may feel that the condition imposed is more onerous than the penalty sought to be remitted. The determination of whether the conditions had been breached rests exclusively in the sound judgment of the chief executive. Absolute. Total extinction of criminal liability. It restores civil and political rights and remits the penalty imposed. The pardonné has no option at all and must accept it whether he likes it or not. In this sense, an absolute pardon is similar to commutation, which is also not subject to acceptance by the offender. Pardon infractions of peace of the state. Amnesty generally addressed to political offenses. Pardon granted to individuals. Amnesty to classes of persons. Pardon exercised solely by the executive. Amnesty requires concurrence of Congress. Pardon granted only after conviction. Amnesty may be granted even before conviction. Pardon looks forward. Abolishes the punishment, but not the offense itself. Amnesty looks backward. Abolishes the offense itself as if it has not been committed. Pardon does not restore political rights, unless expressly restored by the terms. Amnesty, it restores political rights. G. Diplomatic power. The President, being the head of state, is regarded as the sole organ and authority in external relations and is the country's sole representative to foreign nations. As the chief architect of foreign policy, the President acts as the country's mouthpiece with respect to international affairs. The President is vested with the authority to a. Deal with foreign states and governments, b. Extend or withhold recognition, c. Maintain diplomatic relations, d. Ratify treaties, but subject to the concurrence of the Senate, e. Enter into executive agreements, and f. Transact the business of foreign relations. To contract or guarantee foreign loans requisites, a. With the concurrence of the Monetary Board, b. Subject to limitations as may be provided by law, c. Information on foreign loans obtained or guaranteed shall be made available to the public. Entry into treaties or international agreements. Treaty, as defined by the Vienna Convention on the Law of Treaties, an international instrument concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments, and whatever its particular designation. Note: it is the President who ratifies a treaty, not the Senate. The Senate merely concurs. Thus, the President cannot be compelled to submit a treaty to the Senate for concurrence. He has the sole power to submit it to the Senate and/or to ratify it. Executive agreements. Entered into by the President. B. May be entered into without the concurrence of the Senate. C. Distinguished from treaties. Treaties. International agreements involving political issues or changes in national policy, and those involving international agreements of permanent character usually take the form of treaties. Executive agreements. But the international agreements involving adjustments in detail carrying out well-established national policies and traditions, and those involving a more or less temporary character usually take the form of executive agreements. However, from the point of view of international law, there is no difference between treaties and executive agreements in their binding effect upon states concerned as long as the negotiating functionaries have remained within their powers. Notes from the case of Pangilinan versus Cayetano, 2021. The President enjoys some leeway in withdrawing from agreements which he or she determines to be contrary to the Constitution or statutes. Relate it to the President's duty to ensure that the laws are faithfully executed. The President cannot unilaterally withdraw from international agreements which were entered into pursuant to congressional imprimatur. When a statute is adopted, the President cannot withdraw from the treaty being implemented unless the statute itself is repealed. The President cannot unilaterally withdraw from international agreements where the Senate concurred and expressly declared that any withdrawal must also be made with its concurrence. H. Power relative to appropriation measures. Power of augmentation. No law shall be passed authorizing any transfer of appropriations. However, the President of the Senate, the Speaker of the House of Representatives, the Chief Justice of the Supreme Court, and the heads of constitutional commissions may, by law, be authorized to augment any item in the general appropriations law for their respective offices from savings in other items of their respective appropriations. The President may use savings from one office to augment or increase appropriation items in another office, provided both offices are under the executive branch. The President shall have the power to veto any particular item or items in an appropriation, revenue, or tariff bill, but the veto shall not affect the item or items to which he does not object. Borrowing power. The President may contract or guarantee foreign loans on behalf of the Republic of the Philippines with the prior concurrence of the Monetary Board, and subject to such limitations as may be provided by law. The Monetary Board shall, within 30 days from the end of every quarter of the calendar year, submit to the Congress a complete report of its decision on applications for loans to be contracted or guaranteed by the government or government-owned and controlled corporations which would have the effect of increasing the foreign debt, and containing other matters as may be provided by law. President or his alter ego may exercise borrowing power under the doctrine of qualified political agency.